Hi, everyone. We're very happy that you joined us at the contacts and other interactions between different legal orders panel of the annual Minerva IHL Conference. I'm Yali Shereshevsky. I teach international law at the University of Haifa. And unfortunately, we are one panelist short. Anisi was unable to join us today, but we are left with what seems to be two highly interesting presentations, so we will have more time to focus on those papers. I'll briefly present our speakers, and then each will have approximately 20 minutes before we will move on to the Q&A. And please, you can write your questions during the session using the Q&A feature. Okay, so Dr. Natalia Hendel is a research fellow at the Geneva Academy of International Humanitarian Law and Human Rights, and a researcher at the Institute of Information Security and Law of the National Academy of Legal Sciences of Ukraine. She's a member of the advisory board of the Gromada project, which aims to recover Ukraine's environment. Dr. Natalia Hendel is a member of the Ukrainian Association of International Law, a member of the European Society of International Law, and a member of the Environmental Peacebuilding Association. She is the head of the Center for International Humanitarian Law at the Ukraine Association of International Law. Dr. Timur Korotky is a vice president of the Ukrainian Association of International Law, a leading researcher at the Institute of Information Security and Law of the National Academy of Legal Sciences of Ukraine. He is an author of more than 500 academic and research works on international law, and since 2004, he's been teaching and researching international humanitarian law. He participated in projects to document war crimes against museums and religious sites during the Russian aggression against Ukraine, and is engaged in expert advisory, research, and training activities in the field of international humanitarian law. So Natalia and Timur, please, you can present your paper.
Good evening. It's a great pleasure to participate in this conference. It's our second time when we participate in the Minerva conference, and now we will focus on the constitutional circumstances of ratification of Rome Statute in Ukraine. Ukraine society and Ukraine state and the democratic world are seeking the restored justice to Ukraine and ensures that the numerous international crimes committed during Russian aggression against Ukraine are punished. The International Criminal Court is one of the mechanisms of justice. The importance of extending the jurisdiction of the ICC to the territory of Ukraine during the Russian aggression is difficult to question. However, after signing the Rome Statute on 20th January in 2000 and recognizing the jurisdiction of the ICC, under Article 12, Part 3 of the Rome Statute, on the basis of two declarations of Verkhovna Rada of Ukraine in 2014 and in 2015. Ukraine has not yet ratified it, despite numerous political and legal advantages and legal requirements, including obligation under the association agreement between Ukraine and on the one hand and the European Union and the European Atomic Energy Community and the member state on other. Ukraine has now joined the group of states that have made declarations under Article 12, Part 3 of the Rome Statute, but even in this very small group, it stands out for the existence of political and legal obligation and the expediency of ratifying the Rome Statute. But this ratification has been and continues to be hampered primarily by political factors. Under reference to the Constitution of Ukraine in 2001, the decision of the Constitutional Court were used to transform these political factors into legal grounds. Now we would like to distinguish several stages related to the process of the Rome Statute becoming binding for Ukraine in particular. Firstly, signed the Rome Statute by Ukraine in 2000, and adoption of the opinion decision of the Constitutional Court on the conformity of the Constitution of Ukraine with the Rome I'm sorry, can I continue?
Yeah,
Because I have
now,
some
now we can hear you.
problems.
You can continue.
Thank you. I'm sorry, but I can have some problem with connection because in Ukraine we have troubles with electricity and interconnection. And secondly, the recognition by Ukraine of the jurisdiction of the ICC in accordance with Article 12, Part 3 of the Rome Statute in 2014 and in 2015. And thirdly, amendments to the Constitution of Ukraine allowing for the ratification of the Rome Statute. And firstly, the general situation in Ukraine with regard to amendments to legislation on cooperation with ICC and ratification of the Rome Statute. In accordance with the constitutional powers of the President of Ukraine, Article 106, Part 3 of the Constitution of Ukraine, and the law of Ukraine on international treaties of Ukraine, Article 6 of this law, the Rome Statute of the ICC was signed on behalf of Ukraine on 20th January 2000 during the presidency of Leonid Kuchma. During this period, there was a political crisis which led to a change in the attitude of the state leadership towards the ratification of the Rome Statute in Ukraine. As a result, on 13 February 2001, the President of Ukraine submitted a constitutional petition to the Constitutional Court of Ukraine to issue an opinion on the compatibility of the Rome Statute of the ICC with the Constitution of Ukraine before it was submitted to the Verkhovna Rada of Ukraine for binding effect. It should be noted that this was not a unique phenomenon in the history of ratification of the Rome Statute, as the relevant authorities in more than 10 states, including France, Belgium, and Spain, have issued opinions on the compatibility of national constitutions with the Rome Statute. The powers of the Constitutional Court of Ukraine to ensure that international treaties submitted to the Verkhovna Rada of Ukraine for its concerned to be bound or in conformity with the Constitution of Ukraine, its Article 15. To date, the 2001 opinion of the Constitutional Court of the Rome Statute remains the only decision of the Constitutional Court adopted pursuant to Article 15 of the Constitution of Ukraine. In case of incompatibility of international treaties with the Constitution of Ukraine, they conclude that it is possible after amendments to constitutions of Ukraine. According to the constitutional petition, the President of Ukraine was of the opinion that a number of articles of the Rome Statute were inconsistent with the constitutions of Ukraine. 6. In particular, it's paragraph 10 of the preamble of the statute and articles 4, 9, 27, 89, and others. During the consideration of the constitutional petition of the President of Ukraine at the plenary session of the Constitutional the provision of the statute did not contradict the Constitution of Ukraine, and therefore it could be ratified by the Verkhovna Rada of Ukraine without making amendments to the Constitution of Ukraine. Already on 11th July 2001, the Constitutional Court of Ukraine issued its opinion on the conformity of the Rome Statute of the ICC with the Constitution of Ukraine. The Constitutional Court of Ukraine concluded that all contested provisions of the Rome Statute are consistent with the Constitution of Ukraine, with the exception of paragraph 10 of the preamble of and Article 1 of the Rome Statute, according to which the jurisdiction of the ICC is complementary to national criminal justice system. To declare the Rome Statute of ICC signed on behalf of Ukraine on 20th January 2000 and submitted to the Verkhovna Rada of Ukraine for its binding nature, inconsistent with the Constitution of Ukraine in the part concerning the provision of paragraph 10 of the preamble and Article 1 of the statute, according to which the International Criminal Court shall be complementary to national criminal justice system. The second stage of a relation between Ukraine and the International Criminal Court was connected with the recognition of the jurisdiction of the ICC as separate resolution of the Verkhovna Rada of Ukraine caused by the events on the Maidan on 18th to between 18th to 21 February 2014. It was a revolution of dignity in Ukraine, and a second one statement was connection with Russian aggression against Ukraine. A statement by the Verkhovna Rada of Ukraine provided the basis for two declarations to the International Criminal Court recognizing the jurisdiction of the ICC under Article 12, Paragraph 3 of the Rome Statute. During this period, there were statements by high-ranking officials on the immediate ratification of the Rome Statute and legal commitments to ratification were included in the association agreement between Ukraine on the one hand and the European Union on another hand, which were ratified on 16th September 2014. An alternative opinion was also proposed to amend the Constitution of Ukraine by obtain another opinion of the Constitutional Court of Ukraine on the ratification of the Rome Statute. Unfortunately, there were also opinions that ratification of the Rome Statute was not the right approach to counter Russian aggression, and that in the context of the annexation of Crimea and Russian aggression in Donbass, ratification of the Rome Statute is appropriate only if Russia make such a decision at the same time. This variety of approaches reflected the ambiguous approach to the ratification of the Rome Statute. The third stage, in 2016, the Constitution of Ukraine was amended by the law of Ukraine on amendments to the Constitution of Ukraine concerning the also consider the draft law of Ukraine on amendments to the Constitution of Ukraine. I will conclude my point, my speech, my report. Now Ukraine done the changes on the Constitution amendments, and if in Ukraine we have a political will to ratify the Rome Statute, it can be done because we in Ukraine we don't have now a constitutional problem with the constitutional decision, constitutional opinion of the ratification of the Rome Statute. Thank you.
Great. Thanks, Natalia. And now we move to V. Muller. If you can open your camera, great. So V. Muller is an assistant professor of public international law. He joined Maastricht University in 2015. He has worked at the universities of Manchester, Essex, Leiden, and Amsterdam, and for the Bosnian delegation to the International Court of Justice. He's a Doctor of Laws of the European University Institute, where he researched the Chinese approach and practice of public international law. His teaching and research interests include public international law and many subfields such as the law of armed conflict, human rights, international criminal law, international dispute settlement, and the politics of international law, especially regional approaches to international law. Wim, the floor is yours.
Thank you very much, Dr. Yali, I can call you, I guess. I'm very grateful also to the organizers for having me in this conference, and I would like to first start with a note of apology because the presentation as I have it it's a little bit less developed than I hoped it would be, particularly because I'm going to be speaking about a topic that has been written about quite a bit by a few members present here as well. So for them, maybe there is a little bit less news than I would have hoped for, but let's take it from the beginning, because I'm going to talk about the interrelationship between international humanitarian law, international human rights law, and constitutional law, and that, as my title reflects, it's like juggling three different balls of unequal size and weight, because they are, in a way, very different creatures, but they are, and what we see in litigation in recent decades is that they are increasingly being used together by litigants to achieve certain aims. And basically, this has turned a number of doctrinal questions, which used to be a little bit more obscure, into they have developed these doctrinal questions more, but it has also basically made them of more practical importance. So so as I said, the findings are a little bit tentative, but I hope I will still raise some interesting questions. So to start with the question of the relationship between international humanitarian law and international human rights law, the debate has been in scholarship, and also developments in case law have now been going on for a number of decades after being dormant for quite a while. It evolves from a somewhat obscure doctrinal question to one with a lot of ramifications in practice, as I just said. And also originally, particularly the division between international humanitarian law and international human rights law seemed to be a neat division between the law that on the one hand was applicable in armed conflict, and on the other hand, the law that was applicable in peacetime. But that distinction also no longer really is tenable, even though some states are still holding on to it. So a number of recent overviews also have summarized the doctrinal approaches taken, starting from the moment that also the International Committee of the Red Cross identified three main theoretical schools of thought that existed on the topic, which are complementarism, integrationism, and separatism, where separatism is the idea that humanitarian law and human rights law are two very separate fields of law, while the other ones see them as part of the same whole and have different ideas about the relationships between the two fields. So, and some of the recent scholarship also explains in quite a bit of detail how the co-applicability, which follows from both the approach of complementarism and integrationism, has taken shape in practice. And what has become clear is that international and domestic case law have used the simultaneous applicability of international humanitarian law and international human rights law to fill gaps in each other's scope of application, all at the service of protecting vulnerable individuals against the deployment of violence by states. So that's what they kind of share in common. And doctrinal solutions have been found and are increasingly being looked for with various scopes of sophistication. And if you then look at the role of international courts and tribunals in developing the case law of co-application of IHL and international human rights law, that is well established. And to some extent, the same is also true for the work of domestic courts, especially high courts or supreme courts, and in some cases, constitutional courts. However, if you look at the bodies of scholarship, they have rarely met so far. So there's quite a large body of scholarship on the relationship between international humanitarian law and international human rights law on the one hand, and also on the application of international humanitarian law by domestic courts. But they have not really come together to such a large extent, and the time seems quite ripe for them to be examined in more detail together. Now, there are basically two ways I'm suggesting that there are two ways to approach it, because on the one hand, you can do it from a doctrinal point of view and try to make a sense of this triangular relationship, but that might also be seen as a bit of a fool's errand, because the fields of international human rights law and international humanitarian law are already quite different, both their history, but also the way that they work conceptually. Most notably because, most interpretations of international human rights law are based on the assumption that individuals can derive rights directly from human rights treaties, IHL is less straightforward on this question. And if you would add in then the dimension of domestic constitutional laws, you add further fundamental or doctrinal questions to this, most notably about the relationship between international and domestic law, whether treaties can be self-executing in domestic law or whether they require implementation, which courts might apply these rules from treaties, and also to what extent the judiciary should show restraint when it's in interfering with the executive's conduct of foreign affairs. However, if you look at the vantage point of the interests and values which international humanitarian law, international human rights law, and constitutional law all seek to protect, it does make sense to attempt at least some systematization or some alignment. And also, since it has become clear that there are quite a few actors who are looking to use these three fields of law together for the protections that I mentioned earlier, it makes sense to also examine how they have been doing so far in that respect. So in the remainder of my presentation, what I will do is that first I will look at these doctrinal questions a little bit more closely, and then do a quick run through the case law that I've been able to cover so far, and present the findings that I have, and well, hopefully that will then lead to a bit of discussion about where to go from there. And I will, in that case law, I will be mostly focused on the European Court of Human Rights and some Dutch case law, and that doesn't mean that I'm not aware of a very wide body of case law that exists elsewhere, including, of course, in Israel, but I also would not assume that I have more meaningful things to say about that than the scholars who are present here. So if we take stock now after a few decades of scholarly debate about the relationship between international humanitarian law and international human rights law, as I said, there's no longer controversy about their simultaneous application. It has been referred to as a parallel application or co-applicability, or just that they apply at the same time. But by now, there might still be some states that are holding on to the position that when the law of armed conflict starts applying, human rights law stops applying. But in international case law and in doctrine, that is either a minority position or not one that is part of a consensus anymore. It all started, of course, in this round with the nuclear weapons and war advisory opinions of the International Court of Justice, to be followed also by its judgment in the armed activities case. And in the nuclear weapons advisory opinion, the court first limited itself to the observation that the protection of the ICCPR did not cease in times of armed conflict, and that norms of IHL could be read as lex specialis to the lex generalis of the covenant, at least when it came to the right to life, but it didn't really elaborate on that or say anything about whether this was a more general observation about the relationship between those fields in a wider scope. But then in the Wall advisory opinion, the ICJ seemed to present this lex generalis, lex specialis relationship as a more general rule that could be applied in all situations where rights might be, and I quote, may be matters of both these branches of international law. Now, even at that time, there were already quite a few observers who expressed skepticism about whether or not you could always say that IHL was the lex specialis to the lex generalis of international human rights law. But nonetheless, it took on a life of its own in scholarship, and many people were grappling with that for quite a long time. And that is probably because, the lex specialis formula appears to offer a neat doctrinal solution, which basically puts each field of law in its designated space and provides for a conflict rule which answers which set of rules takes priority. But it does not take account of the fact that international humanitarian law and international human rights law have very different origins, that they address different actors in a way in their obligations, even though, of course, the primary addressees are states. And that their overlap primarily stems from their common overall aim to protect the human persons, and those situations in the real world in which rules from both might be applying at the same time, but they were never designed in a way to work in a lex specialis, lex generalis relationship. And also qualifying one of the two as special might be, to quote Catherine Fortin, akin to a separatist approach in a complementarist clothing, in which you are still basically saying that during armed conflicts, international humanitarian law takes precedence and that international human rights law recedes to the background. But then it's not an argument to not to apply human rights law at all, but just to put it more in the background. So in that sense, it's not really surprising that since then, the thinking has evolved and has moved more towards complementarity, which is also more in line with the approach that you would derive from general international law. Often reference in this regard is made to Article 31, paragraph 1c of the Vienna Convention on the Law of Treaties, which basically puts as a general order principle that international law tends towards systemic integration, and that therefore, when different rules apply, they should be interpreted in a complementary way, and rather than focusing on their differences. And in support of that, you could also refer to the fragmentation report of the International Law Commission, which referred to this principle and presented it as kind of the model for a reconciliation of different areas of international law where multiple norms apply. Now, if you look at that, then you can also ask, well, is there a way to integrate domestic constitutional law into this consideration as well, especially if a certain situation falls under that field of application? Well, of course, that opens a whole other kind of worms, which is that, the relationship between constitutional law and international law in general is also determined by the views that you might have about the relationship between domestic law and international law in general. Also, if you look separately from the point of view in which international human rights law is supposed to be implemented in the domestic legal orders of states, and also how international humanitarian law is supposed to be implemented in domestic order of states, there are also considerable differences. International humanitarian law is, of course, the older field of law and is therefore more framed in a contractual way. Even the newer treaties of international humanitarian law still primarily impose obligations on states rather than on granting any rights, and they also contain specific provisions that basically oblige states to implement them. And there are not really any general rules about what to do then in case these IHL rules are violated. International human rights law, on the other hand, is different, even though it is framed in a contractual format. From the beginning, from the Universal Declaration of Human Rights onwards, of course, the language of the provisions suggests that individuals can derive rights directly from human rights treaties. And this is definitely also the way that human rights bodies see it. For example, if you look at General Comment 31 of the Human Rights Committee, it also says that the covenant cannot be viewed as a substitute for domestic criminal or civil law, but the positive obligations on states or parties to ensure covenant rights will be fully discharged if individuals are protected by the state, not just against violations of covenant rights by its agents, but also against acts committed by private persons or entities that would impair the enjoyment of covenant rights insofar as they are amenable to application between private persons or entities. So there it is quite clear in what way human rights need to be realized at the domestic level. Also, if you look at general international law, there are a number of expressions of the rule that states cannot escape from their international obligations by referring to provisions of domestic law, which can be applied in different contexts, but which you see, for example, in Article 46 of the Vienna Convention on the Law of Treaties, which by now also reflects customary international law, as well as, for example, in Article 32 of the Articles on the Responsibility of States for Internationally Wrongful Acts. So what you then see is that, at least doctrinally speaking, and from a perspective of legal theory, it is very difficult to create a conceptual system in which converges, or which would basically allow rules from the three different fields to work together in a kind of consistent or systematic way. And to the extent that it is possible, that it would probably require also quite a bit of legal development, which in the current day and age does not seem the first thing that is going to happen. Also because at the moment, worldwide, we see a bit of a pushback against overactive courts, both with regards to international courts and tribunals, but also to domestic constitutional courts if they stretch their interpretations or if they are perceived to be stretching them too far. Now, if you look then at the way in which in international and domestic case law, then actually these three fields of law have worked together. Basically, we also see how these problems in doctrine that I've just described work out in practice. If we look back, you see that particularly in the last, let's say, 3 decades, there has been a proliferation of case law in which either human rights law and international humanitarian law are being applied together, or international humanitarian law and constitutional law, and sometimes even all three, because constitutional law can also be a vehicle through which international human rights law is applied in a domestic legal order, particularly if it happens before people would resort to international litigation. The situations that we then see, if we focus in particular on the European Convention on Human Rights, is that simultaneous application has occurred when human rights were at stake in a situation where there was also an armed conflict. So that includes situations of belligerent occupation, such as the occupation of northern Cyprus by Turkey or other cases. Historical situations of armed conflict, such as cases about reparations for violations of international humanitarian law in historical armed conflicts, also going back all the way to the Second World War. But also in particular constraints on the way to states would be able to act in what is referred to as the global war on terror, where we also see that international humanitarian law was sometimes introduced as a legal framework, even in situations where it didn't necessarily apply. There are quite a few different legal issues which have come up, some of which refer to the interplay between different fields of law, but sometimes there are only some concepts have come up which are not directly relevant. But I will get back to that in a moment. First and foremost, the scope of application. So in which situation do international humanitarian law and international human rights law apply at the same time? For that, of course, for IHL, you need to classify the conflicts. For human rights law, it would also be worthwhile to see if any derogations have been made. And in particular, in the field of human rights law, the question is whether the human rights obligations of a state might also apply outside of its own borders. And in that regard, the case law has also developed the criteria that exist for this question to be answered. What we also see is that different systems have actually taken slightly different paths. So I've looked more closely at the European Convention on Human Rights, but also a bit at UN treaty bodies. But I'm aware of the fact that the Inter-American Court of Human Rights has expressed itself also differently on the application of international humanitarian law than some of the other international bodies. And then, in addition to that, there's also the relevance that some of these findings have had for domestic law. Now, what we see in common is that if you look at the litigants which have appeared before different bodies, is that what they all have in common with each other is that they are specifically focusing on the aspect of the 3 different fields of law that aim to protect human individuals. So one area of constitutional litigation, for example, was in the United States also, particularly when it concerned the detention facility at Guantanamo Bay, which was originally intended to be designed as a kind of like a legal black hole, but where litigants before the US Supreme Court managed to use both a combination of international humanitarian law and constitutional law of the United States to at least establish some protection for the detainees who were in there. And that was a situation in which the International Covenant on Civil and Political Rights had a limited reach because of the way in which that treaty is not self-executing in the domestic order of the United States. What we see for the European Court of Human Rights in particular is that it has served as a venue for people who want to hold European states to account, who have also have operated in Afghanistan, Iraq, and elsewhere. Also in the context of international operations, which were part of this global war on terror, or also in other contexts. And the way in which the case law developed in that respect, and and the way in which it's particularly developed in the area of extraterritorial jurisdiction, then also had an impact on, for example, domestic cases before the Dutch High Court. Most notably in the Srebrenica case, where international humanitarian law was not really applied, but the impact of the case law on extraterritoriality had quite a large impact on the extent to which the actions of Dutch forces in Srebrenica could be judged by the Dutch Supreme Court and lower courts before that. Now, what you see is that this litigation has offered both limitations, and notably in the scope of application, because it is quite rare that international humanitarian law and international human rights law have actually been able to apply simultaneously, most notably because of the limits of extraterritorial jurisdiction. And one example of that is a case which took place before a Dutch court last year, which is known as the Chora case, concerning Dutch forces that were operating in Uruzgan in Afghanistan, and may or may not have been acting in accordance with international humanitarian law when they were bombing a certain residential complex which mostly was housing civilians. In that specific situation, the Dutch District Court of The Hague found that the Dutch government had violated its obligations under IHL, because there was no clear indication that this residential complex had in fact been a military objective. Although the main reason why the court found it at that instance was that the Dutch government was not able to provide sufficient information about its targeting decision, which took place in the context of an international mission under the umbrella of NATO. And for that reason, it was not able to establish that it was in fact a military objective. Now, in that case, the Dutch court did apply some of the criteria for extraterritorial jurisdiction also under the European Court of Human Rights, but actually found that the European Court of Human Rights did not apply because there had not been an investigation in the Netherlands. And that for that reason, none of the criteria for special features which have recently been developed in European Court of Human Rights case law as an additional factor for extraterritorial jurisdiction was met. Now, that takes me back to one earlier criterion, which is that the case law of the European Court of Human Rights has by now become quite well established about when extraterritorial jurisdiction applies, which is mainly in situations where the state either is exercising control over territory or exercising control over persons. It took quite a while to develop or to get clarity into those criteria. But then in more recent cases, the European Court of Human Rights has also allowed for some special features of specific individual cases without actually defining what those special features look like, to still extend the jurisdiction under the European Convention on Human Rights in specific cases. This happened, for example, in the interstate case between Georgia and Russia, but also in one case against Cyprus and Turkey, which also had to deal with something that happened in the Turkish Republic of Northern Cyprus. So this development, which is quite recent, illustrates that that it's still quite a bit of a challenge to find situations in which the obligations of states under human rights treaties also apply extraterritorially, and it also looks as if that is an area where there's still quite a lot of room for further development of the criteria so that we can get more legal clarity. I will just summarize my main findings so far, which is that the main reason to try to systematize the workings of international humanitarian law, international human rights law, and constitutional law together is basically because they protect individuals in different ways, and when they are made to work together, they might actually provide more protection or plug holes in the protections which are maybe not fully realized in certain fields of law. As one example, in international humanitarian law, the possibility to impose a duty of obligations on states is quite limited, while in the case law on human rights, this has developed a lot more. The Chora case before the Dutch courts that I just mentioned is actually one example, although one in which it didn't work out. And in that sense, it is a bit of regrettable that that case was not appealed by the Dutch government, which might have clarified the legal criteria for the application of the European Court of Human Rights a little bit more, because the reasoning of the district court is a bit thin. Although from the point of view of the litigants, that was quite good, because the Dutch government acquiesced in that judgment, and therefore the victims were actually entitled to some compensation as a result. Now, in international law, what if I say that what international human rights law and humanitarian law have in common is that many of their professions aim at protecting individuals, tends to lean more towards the humanization thesis, which also has been open to quite a bit of criticism, because even to the extent that maybe the increased protection of human beings under international law has been put forward, of course, by a number of scholars, including most notably Theodore Meron. But skepticism has also been expressed to it because the protections only reach so far. At the same time, if you look at the way in which it has worked in the litigation, all three fields will clash with state sovereignty in different ways. Because, well, international humanitarian law, for conceptual reasons, also because it is not quite clear to what extent individuals can derive rights from it, but also because it's still primarily directed at states and provides them quite a lot of leeway in the interpretation of the field. And human rights law, because of the limited scope of application and the limits of extraterritorial jurisdiction. And in constitutional law, because constitutional courts can work in two ways, because they can extend the protections also that they derive from international law, but they can also act as a limit on the exercise of rules that have been laid down in international law. And in that sense, what would be interesting to look at is how sovereignty is going to be defined in the future and redefined, because politically speaking, it can also be recast as an expression of the wish to protect our common humanity, or because sovereignty is, especially in democratic societies, seen as an expression of the people as a collective. But that's not always the way that it is being applied by states. Well, so I will leave it with these remarks. I hope that despite the tentative nature of them, it still made a bit of sense. Thank you for your attention.
So thanks very much, Wim and Natalia. I remind you again all that you can use the Q&A to write your questions. The first question is to Natalia, and It's from Ben Clark, and maybe I'll modify it just a bit. So it asks about the potential implications of the potential indictment of Israeli officials by the ICC on the approach in Ukraine to the Rome Statute, to the ratification, perhaps constitutional change, or more broadly, the approach towards the ICC, focusing on the potential, perhaps adverse implications on Ukrainian officials themselves.
Thank you for this question, and we understand that the current situation with arrest warrant of the Israel officials 100% influence to Ukrainian position of ratification of Rome Statute, because we have this problem with the political will of the ratification of Rome Statute, but now we in Ukraine has not the legal problem with ratification of Rome Statute, because all changes was adopted in Ukrainian national legislation, including the Constitution of Ukraine. But I would like to mention that Ukrainian human rights organization prepared several statements about that Ukraine has to ratify the Rome Statute. For example, in Ukraine, after full-scale invasion, was created two coalition of Ukrainian human rights organizations. One of them names Ukrainian 5 AM Coalition, and another one is Tribunal for Putin's, and all these two human rights coalitions have their position that Ukraine has obligation of ratify the Rome Statute under the Agreement of Association with European Union. It's first argument, and the second one that now the legal dilemma was resolved in Ukraine with constitutions, and I think Ukraine supports and solidarity with Israel, and this news maybe one more argument about for this moment Ukraine does not ratify the Rome Statute, for example. Thank you.
Thanks. And a question to Vin. I wonder about the role of constitutional law in this interaction between the three bodies of law. And specifically, do you see a potential development that is similar to the development regarding the relationship between IHL and human rights, in the sense that from a lex specialis it moved to a more complementary, focusing on how human rights maybe can inform gaps in IHL? So I wonder, do you see any way in which domestic constitutional law, maybe a domestic human rights law, can inform the way that we interpret IHL through domestic case law?
Okay, maybe just to ask you more specifically, do you mean also human rights that originate in a domestic context, or more that or human rights applied through domestic courts?
So I think that right, we can think about the two options. One is to think that constitutional law can actually affect the relationship between IHL and human rights through interpretation of the application of human rights in conflict. But this is just part of the general trend. But we can also think of the possibility, similar perhaps to the targeted killings case, where the court applied a domestic constitutional doctrine directly to IHL in a very similar way to the way that human rights law affected IHL in other contexts.
Yeah, I think, well, okay, so if I understand your question correctly, I think in principle, domestic courts might actually have have more ways to implement human rights law and basically interpret also international humanitarian law in the light of domestic human rights obligations than international courts do, because there might be some fewer jurisdictional constraints depending on the way that human rights are defined in the national constitution. Because, of course, if a domestic court would apply an international human rights treaty, substantively, it is bound by the same jurisdictional constraints as an international court. But if the domestic constitution also contains provisions on the protection of human rights, it might actually apply them more broadly than, for example, an international body might be able to, because it might not be limited as much by notions of extraterritorial jurisdiction. Yeah. So I think that might be possible, but it depends then very much on the domestic jurisdiction about which we were speaking.
Yeah. Are there any other questions from the participants or the audience? Yeah, we have any question. So there's another question from Ben Clark, and regarding the interplay between the three bodies of law, have you considered or come across any scenarios or cases dealing with these situations? The first one is where the de facto authority controlling the state is not recognized as the government by other states. And the second one is where the government doesn't have a written constitution or suspends it. This question is to Vin. Yeah.
Yeah, I think the first situation, the first example I can think of is actually the Turkish Republic of Northern Cyprus, but where the occupation, or that authority is not actually recognized, although of course the government of Cyprus considers that it is the sovereign over all of Cypriotic territory. But you can see in the cases that have dealt with it by the European Court of Human Rights that it has been quite practical about it. Like, well, the first case of extraterritorial jurisdiction was the Loizidu case, in which it's recognized that because Turkish was the military occupier, that it had obligations there. But the one that I mentioned, the more recent one, is a case in which a crime had been committed, and it wasn't quite clear if it was either in the Turkish Republic of Northern Cyprus or in the Greek part. But the more pragmatic solution of the European Court of Human Rights was that it's basically found that both Cyprus and Turkey could have obligations in this respect. But there it is. But this is made more. This is partially made possible by the fact that, of course, both of these territories are subject to the European Convention on Human Rights, and there are multiple cases where then it's unclear who the respondent state should be, because there is a situation of occupation, but at the very least, the court tends towards finding a solution in which the European Convention on Human Rights applies in some way. But I'm not sure if that is completely the situation that is being described there. Secondly, where the government doesn't have a written constitution or suspends it, I don't have a case that immediately comes to mind right now. So yeah.
So I understand that some panelists have trouble to write Q&As in the Q&A feature, so you can use the chat and I can read it from there. And I have a question to Natalia. And you mentioned in your talk that there was some problem, some conflict between the Ukrainian Constitution and Article 1 of the Rome Statute, and you emphasized the complementarity in this regard. So could you explain maybe a bit more how does complementarity conflicts with the Ukraine Constitution and how the problem was resolved?
Thank you for this question. Yes, we have the decision of Constitutional Court with the Constitutional Court concluded that Ukraine could not ratify the Rome Statute because for that moment it was the problem with understanding with principle complementarity in Ukraine, and that's why it's only one decision, legal decision was took that to adopt new law to make amendments to the constitutions of Ukraine in the part of the justice part, and in this new law had the provision that Ukraine can ratify the Rome Statute, and in this provision mentions the period when it can be done, and it's very interesting because this law of the amendments of the Constitution of Ukraine in the part of the justice was adopted in 2017, but the provision about when Ukraine can ratify it, the Rome Statute mentioned in this law the year was the possible adoption was mentioned in 2019, and after 2019, Ukraine, if Ukraine has this political will and Ukraine Верховна Rada would to ratify Rome Statute, now we have the no legal problem to do this.
Yeah. Yeah. So another question from the chat. And this is a question to both of you. If the trend with more domestic war crime cases continues, as well as the ICC prosecutors' policy to focus on the most responsible, could domestic criminal courts become the primary developers of international criminal law through a field of comparative international criminal law? And is that desirable? Are national courts generally, in your opinion, fit to deal with issues of IHL and ICL and make use of international case law and foreign cases on international crimes? Whoever wants to be.
I can start. I would like to share the Ukrainian experience in this issue. Now the Ukrainian legal system actively works with war crimes and crime genocide and crime aggression. Ukrainian criminal court doesn't have the crime against humanity. That's why Ukrainian prosecutors cannot investigate and prosecute crime against humanity, but Ukrainian legal system and General Prosecutor Office and Ukrainian Regional Prosecutor Office can investigate and prosecute the war crimes. And now we have in Ukraine more than 130,000 criminal proceedings on war crimes, and Ukrainian courts had near 80 court decision of the violation of Article 438 in Ukrainian Criminal Code is a violation of customs and laws of war. It's the same as war crimes, and we see that the Ukrainian national system tries to bring perpetrators to justice, but also we understand that we have a lot of technical problems because it's about to identify the perpetrators who was committed some crimes in the specific areas in Ukraine, because Ukraine is a big country, and sometimes we Ukrainian prosecutors, investigators don't have the access for the occupied territory and don't have the technical opportunities to investigate some specific war crimes, for example. But at the same time, in Ukraine were opened several criminal proceedings of crime of aggression and crime of genocide against Ukrainians. And now we understand why it was very important to create the special tribunal for the crime of aggression, because we understand the question of the immunity, for example. Thank you.
Tim, you wanna?
Yeah. I think, I think it's a fascinating question. I think, because one thing is that, of course, the aim of the Rome Statute of the International Criminal Court is actually to achieve just that, in the sense that, all the states parties to the Rome Statute are expected to criminalize all the crimes that are in the Rome Statute. So, in a way, substantively, that should create criminalization of the same international crimes everywhere. But of course, that doesn't mean that all those states will suddenly also have the same type of criminal procedure. So there is a chance that the way that it is being that those crimes are being prosecuted might differ from state party to state party, and then the question would also be whether their substantive interpretation of those crimes might also differ. But although I think with the crimes that are specifically in the Rome Statute, that is not really supposed to happen. But for the time being, there might still not be enough practice to really see whether or not they are diverging in that respect. But for example, in the Netherlands, we have there is a specific crime for a specific law for international crimes, and a special section of the District Court of The Hague that deals with them, and that is at least partially also in order to comply with the obligation of the Netherlands under the Rome Statute. So that's definitely happening. I don't know if you would call it comparative international criminal law in the sense that they are all supposed to be substantively the same crimes. But at the same time, if you look at, for example, at things like genocide, there are older definitions in different states which are already a bit different. Like, for example, in Latin America, there are some states that also treat political genocide as genocide, while that's not the case in other states. So I don't know what kind of impact this has on the kind of definitions of certain crimes that might already have existed.
Yeah, right. And to Natalia, it is related to the previous question to some extent. So to what extent the internal debate in Ukraine was a doctrinal debate about the relationship between the Constitution and the Rome Statute, and to what extent did it involve political questions such as potential fear that Ukrainians will be prosecuted by the ICC rather than just Russians? And do you see initiatives just like in other states, such as investigatory mechanisms that intend to address potential ICC intervention?
Thank you for question. And first of all, I would like to mention that Ukraine recognized the jurisdiction of ICC under the Article 12, Part 3, Paragraph 3. That means that if Ukrainian military authorities and generals committed war crimes, crimes against humanity or genocide, it can be prosecuted by ICC, because it's not only in the one way only for Russian perpetrators. If Ukraine and another another hand of this situation, first of all, the obligation to investigate, prosecute for war crime, for grave breaches of IHL, serious violation of IHL, is a state obligation. And Ukrainian legal system shows that if Ukraine knows this fact when the Ukrainian military forces committed war, for example, committed war crimes, I believe, and I work with Ukrainian prosecutors and Ukrainian justice that this situation will be investigated by national level, because first of all is a priority for investigating and prosecuting on the national level. That's why for Ukraine it's very important to to implement IHL and human rights too, not only IHL in this sphere. And we do a big work on this in this way. And now we work with Ukrainian prosecutors and judges how to do this more more strong, the Ukrainian position in the war crimes, because I mentioned before that we have only one article about war crime in Ukrainian criminal code. This article is a blanket norm. That means that Ukrainian prosecutors and judges and lawyers in this procedure should use all IHL treaties that ratified Ukraine, but Ukraine ratified almost maybe all the IHL treaties, only as a conventional cluster munition we didn't ratify yet, and that's why, first of all, I think if we know about the Ukrainian war crimes, national system will try to investigate, prosecute, and bring to justice these perpetrators. And secondly, about the relationship between Ukraine and ICC. Ukraine now has strong relationship between Ukraine and ICC. For example, Ukraine made amendments to Ukrainian procedure, Ukrainian Criminal Procedure Court, which have a separate part which contains the provision about the mechanism of cooperation between Ukraine legal system and ICC. That's why it's a step to cooperate with ICC in the investigation of the situation in Ukraine.
So, if there are no other questions, thanks very much to Natalia and Vim, and the next session will start around 6:30.